Welcome back, deep divers. Ready to unravel another intriguing legal knot? Today, we're diving headfirst into the world of contract law, and specifically, those oops moments we call mistakes.
Yep, we're talking about those times when a genuine misunderstanding or a slip-up can actually make or break a contract.
That's right. So consider this. You walk into a bakery, order a cake, and ask for chocolate. But on the big day, uh-oh, it's vanilla. The baker misheard you. Now, is that just a frustrating situation, or is that a legal mistake?
Well, it's definitely frustrating, but legally speaking, it might not qualify as a mistake.
Sure.
See, in contract law, there's a crucial difference between a simple misunderstanding and an actual mistake.
So how does the law differentiate between a simple misunderstanding and a real deal-breaker mistake?
A mistake, legally speaking, is a belief that just doesn't line up with the facts at the time the contract was made. Think of it this way. Misunderstandings happen when we interpret things differently, but a mistake is about the nitty-gritty facts themselves.
So, in our cake case, it's not that the baker was wrong about an existing fact, like having enough sugar or flour. It's more about a communication hiccup.
Exactly. It's like ships passing in the night. Section 151 of the Restatement of Contracts spells it out. It defines a mistake as a belief that's out of sync with the actual facts when the deal is struck. Your cake scenario, definitely a misunderstanding, not a mistake in the eyes of the law.
Okay, so misunderstandings aside, what happens if only one person is mistaken about a crucial fact?
That's where things get really interesting. It's called a unilateral mistake, a one-sided error, essentially. And believe me, it happens more often than you'd think.
I bet. So give us an example of a unilateral mistake that's played out in court. What are some of the cases that illustrate this concept?
All right, so picture this. It's 1969, and we're in court for Boise Junior College District versus Matt Teff's Construction. Matt Teff's, the construction company, is bidding on a big project, but they've made a pretty significant math error in their calculations.
Uh-oh, that doesn't sound good. Did this math mishap end up costing them the contract?
Well, their bid ended up far lower than it should have been, and we're talking a considerable sum of money. The court, however, made a surprising decision.
Really? I'd imagine they'd hold the company to the bid, right? I mean, a deal's a deal, isn't it?
You'd think so, right? But the court actually sided with Matt Teff's, the construction company. They recognized that forcing a contract with such a major error would be incredibly unfair.
That's interesting. So it's not always as simple as you signed on the dotted line, so you're stuck with it.
Not always.
Hmm.
But hold on. This doesn't mean you can just cry mistake every time you end up with a bad deal. Proving a unilateral mistake is a lot tougher than you might think.
So there's more to it than just saying, oops, my bad. What makes it so tricky to prove a unilateral mistake in court?
To get a contract voided because of a one-sided error, it has to be a lot more than just a bad bargain. It has to be so glaringly off base that enforcing the agreement would be, well, let's just say, unconscionable.
Unconscionable. So we're talking about a level of unfairness that's just off the charts.
Exactly. It has to be something that would make someone look at the situation and say, whoa, that's just not right.
Hmm.
And even then, it's not always a slam dunk.
So what else do the courts consider when evaluating these cases? What other factors come into play?
Another situation where unilateral mistake might hold up is if the other party knew or should have known about the mistake given the circumstances. It's all about fairness, right? If someone tries to pull a fast one and take advantage of your obvious error, well, that's just not playing by the rules.
That makes sense. So we've talked about what happens when one side makes a mistake, but what about when both parties are in the dark? Sounds like a recipe for even more contractual chaos, doesn't it?
You're right. That's when we enter the territory of bilateral mistake. And it's essentially a two-way street to unwinding a deal, and it all hinges on both sides being mistaken about a key fact.
So it's like, wait, we both messed up. I like it. Got any real-world examples of this bilateral mistake in action?
Oh, absolutely. One classic case that always comes to mind is Sherwood versus Walker from way back in 1887. It involved a cow, believe it or not.
A cow. Okay, now you've got my attention. What's the story with this cow?
All right, so picture this. A farmer is selling a cow, and both he, and the buyer, are convinced she's barren, meaning unable to have calves. But here's the kicker. The cow turns out to be pregnant, which of course makes her a whole lot more valuable.
Wow, talk about a plot twist. So naturally the seller wants out of the deal, right? I mean, a pregnant cow's worth a whole lot more than a barren one.
Exactly. And that's where the court stepped in. They ruled that the mistake was so fundamental to the agreement. I mean, a pregnant cow is practically a different animal from a barren one, wouldn't you say?
I'd say so. So the court actually allowed the contract to be avoided just because of this unexpected pregnancy.
They did. They recognized that both the buyer and the seller were operating on a false assumption that went to the very core of their deal. It was a classic case of a bilateral mistake.
Wow, that's wild. So does that mean that anytime there's a misunderstanding, people can just shout bilateral mistake and walk away from a deal?
Well, not quite. It's not always that simple. Remember our earlier chat about assuming risk? That idea pops up again in these situations.
Right, so sometimes you're just stuck with the consequences, even if it's a mistake. Are there any particular cases that illustrate this point?
Yeah, absolutely.
Hmm.
Let's shift gears from cows to real estate for a moment and look at the case of Lennery County Board of Health versus Messerly back in 1982. This one really highlights how assuming risk can change the game.
Okay, I'm all ears. What kind of real estate drama unfolded in this case?
So in this case, you've got a couple who bought a property as is. Those two words are key here. What they didn't know, and neither did the seller, was that the septic system was a disaster waiting to happen. We're talking raw sewage leaking to the ground.
Ugh, that's every homeowner's nightmare. Sounds like a textbook case of buyer beware, wouldn't you say?
You'd think so, right? It seems like a clear-cut bilateral mistake. Neither party knew about the faulty septic system.
Mm.
But here's where it gets interesting. That as-is clause changes everything.
So even though both sides were clueless about this major problem, the as-is clause still shielded the seller.
Exactly. By agreeing to buy the property as is, the buyers essentially took on the risk of any hidden problems, no matter how big or small, even a sewage issue.
Wow, that really drives home the importance of understanding the fine print, doesn't it? It's those seemingly small details that can have major consequences.
Absolutely. And it's one of the reasons I always encourage people to read every word of a contract before signing. It can be the difference between a smooth transaction and a legal nightmare.
No doubt about it. So before we move on, let's do a quick recap of what we've learned so far about these contractual mistakes. What are the key points our listeners should remember?
All right, so when it comes to those one-sided mistakes, where only one party got it wrong, they're definitely trickier to undo. The courts really set a high bar for proving them. Bilateral mistakes, on the other hand, those we both messed up moments, often make a contract voidable, meaning it can be canceled. Remember our cow case. But, and this is a big but, if one party has assumed the risk, like with those as-is clauses, the contract usually stands, even if there's a mutual mistake.
So it's really a matter of being informed and protecting yourself. Knowing about these potential pitfalls could save you a lot of headaches down the road, right?
Absolutely. And, if you ever find yourself in a situation where you think a mistake, whether it's yours or the other party's, might give you grounds to void a contract, it's always a good idea to chat with a legal professional.
Makes sense. Sometimes a little expert advice can go a long way.
Couldn't agree more. They can help you navigate all the ins and outs and fight for your best interests.
Great advice. Well, deep divers, we've journeyed deep into the world of contract law today, exploring the fascinating realm of mistakes. From those cake order mishaps to those surprising pregnant cows, we've seen how a simple oops can have big legal implications.
And remember, just because you sign on the dotted line doesn't mean you're always locked into a bad deal.
Exactly. Understanding the nuances of contract law, like those unilateral and bilateral mistakes, can really empower you to negotiate fairly and avoid those contractual nightmares.
It's all about being informed and knowing your rights.
Couldn't have said it better myself.
Mm.
So next time you're about to sign on that dotted line, remember what we've discussed today. Read the fine print, be aware of those potential oops moments, and never hesitate to ask questions. Until next time, happy deal making, everyone.